Hi class, we spent a good amount of time covering negligence. We're now going to switch over to intentional torts. After completing this chapter, you should be able to identify the elements of assault, battery, false imprisonment, and infliction of mental distress, or also known as intentional infliction of emotional distress. Identify the elements of trespass to land, trespass to chattels, and conversion. Recognize circumstances in which it is appropriate to raise the defenses of consent or necessity, and recognize when force can be used to defend yourself, others, property, or to regain possession of chattels or to re-enter land. So what is an intentional tort? Well, it's what it sounds like. We're focusing on the element of intent, also known as the state of mind. As it relates to intentional tort, what we're looking for requires the intent or desire to bring about a specific consequence. For one to be aware that certain circumstances are substantially certain to result in harm, regardless of whether or not the individual intends to cause harm. They only need to have the intent or desire to bring about a consequence, or to be aware that a certain circumstance or harm is substantially going to happen. So if an individual knows with substantial certainty that a result will occur, he or she will be liable for those consequences. Keep in mind that intent needs to be distinguished from motive. Intent is a desire to bring about a specific consequence, whereas motive is connected to the reason for desiring such a consequence. What we're really focusing on here is intent and not motive. Under the transferred intent doctrine, the defendant's intent towards one person can be transferred to the person who is actually injured as a result of the defendant's conduct. So where a tortfeasor is deemed to have committed an intentional tort, this same rule will be applicable if the tortfeasor intends to commit one kind of tort and in fact really commits another one. So for example, if a tortfeasor uses his dog to terrorize person A, which is an assault, and the dog escapes and instead bites person B, which is a battery, the tortfeasor will still be liable for the battery even though he intended an assault initially. So this is an example of the transferred intent doctrine. Intentional torts can further be broken down into two types of torts. There are torts against the persons and torts against the property. First, we're going to cover the torts against the person. Battery is the intentional infliction of harmful or offensive contact upon a person. A defendant will be liable even for unforeseen consequences. So as I just mentioned earlier, whether the tortfeasor intends to actually injure the plaintiff doesn't matter in a tort of battery. To satisfy the elements of battery, the tortfeasor must only intend to make contact, and the contact must actually be made. So what counts as contact? This really extends to contact with any part of a person's body or anything attached to or identified with the body. So this could be touching a person's purse. If, let's say, I'm holding an envelope and somebody makes an offensive touch to the envelope, that's still considered to be that still rises to the level of contact. Even if I'm riding in a car and somebody attacks a car or hits a car, this would still rise to the level of contact, which is required, which is a required element in proving battery. Now keep in mind that neither the plaintiff has to suffer pain or bodily damage in order to cover for battery. The contact only needs to be offensive. So in determining whether a contact is offensive, the real question is whether or not a person with a reasonable sense of dignity would be offended. So if my son comes up to me and holds my hand, this would not be considered offensive because he's my son, he's somebody I know, and I would expect to hold my hand. What we're really looking at here is contact between strangers or individuals, not even strangers, people who don't want to be touched, and would consider being touched as offensive or harmful. So let's say a defendant grabs a plaintiff around her waist and playfully squeezes her as like a joking kind of hug. Typically, a normal person wouldn't crush or kneel over or yell out in pain when being playfully hugged in this way. They might be annoyed, as I would be, as someone who doesn't really like to be touched. But let's say I was suffering from osteoporosis and I sustain a fractured rib because of this playful hug. The defendant in this case would be liable for the full extent of my bodily harm, even though he didn't expect me to have osteoporosis. So if you recall the eggshell skull defendant or eggshell skull rule, similarly for a tort of battery, the defendant will be liable for unforeseen consequences relating to their conduct. So what about assault? Assault is defined as the intentional causing of an apprehension of harmful or offensive contact. It doesn't mean fear necessarily when you're thinking of apprehension, but it does require the plaintiff to be aware of the impending contact. So while under the tort of battery, the plaintiff need not be aware of the contact, under assault of tort, there is a requirement that the plaintiff be aware of the impending contact. So if A intends to frighten B by discharging a pistol behind him, but B, who's deaf, doesn't hear the pistol, A would not be liable to B for assault. Additionally, an individual will not be able to recover for assault if his apprehension is that someone else will be touched and not himself. So the apprehension has to relate to the person themselves. So if for a husband, for example, disarms a robber just before he shoots the husband's wife, the husband cannot recover for assault because the attack was directed at his wife and not himself. Now the wife, however, would be able to allege assault on behalf of herself. Again, the apprehension requirement doesn't require that a plaintiff need to be fearful that they will be harmed. It simply requires that he or she have awareness that the contact is impending and imminent. So any threats of harm must be imminent or be expected to happen immediately to constitute an assault. So any threats of future harm are insufficient, although those might satisfy the criteria for the tort of intentional infliction of mental distress, which we'll cover in a little bit. So if A threatens to shoot B, but she has to go out to her car, to her glove to grab the gun, she hasn't committed assault in this situation because the harm is not imminent. She still has to take additional steps to carry out her threat. Now, some courts are split as to whether or not words alone constitute an assault. Some courts require that such threatening words be accompanied by some overt act that tends to enhance the threatening character of the words, whereas other courts don't require any accompanying act, and they will consider threats that are sufficiently credible to rise to the level of a threat, or words alone to rise to a level of threats. So keep in mind that as soon as the plaintiff apprehends the contact and the tort of assault has been completed. So even after a defendant changes his or her mind or his plan, so long as the plaintiff has already apprehended the contact, the defendant will still be liable for assault. The tort of false imprisonment is committed when a person intentionally confines another. This includes restraint in an open street or in a moving vehicle. This also will include threatening body language. Confinement can be achieved by something less than physical force. So threats that are aimed at the plaintiff or to somebody somebody else, a third party. If the plaintiff leaves the area, the defendant in that case has committed false imprisonment. So in this situation, for the tort of false imprisonment, threats do rise to the level of confinement, but similarly, they must be of imminent harm. So threats of future harm will not be sufficient. Additionally, the plaintiff must be aware of her confinement at the time it occurs. So if they're unconscious but later discover that they were confined, they can't claim that they were falsely imprisoned. They have to be aware of their confinement. False imprisonment typically arises in law enforcement or shoplifting cases. As it relates to law enforcement, police officers can assert their right to make an arrest, which will likely be a valid defense to the tort of false imprisonment. They can claim this as a defense even if the arrest or detention turns out to be unlawful. They're only required to act reasonably and in good faith in carrying out the arrest. So even an officer who serves a plaintiff with an invalid warrant, but who reasonably believes the warrant to be valid, has not committed false imprisonment. So keep in mind this exception for police officers as it relates to false imprisonment. There's also the shopkeeper's privilege as it relates to customers and shoplifting. In most states, a merchant has a right to detain a suspected shoplifter for a short period of time for the purpose of investigation. This right or this privilege is very restricted, and it's lost if the detention is unreasonably long, if the plaintiff is bullied or insulted, if the plaintiff is publicly accused of shoplifting, or if the detention is used to coerce payment or the signing of a confession. So there are exceptions for false imprisonment as they relate to law enforcement, and very restrictive privileges as well as it relates to shoplifting and the shopkeeper's privilege. The tort of infliction of mental distress or intentional infliction of emotional distress can either be committed intentionally or recklessly. If it's committed intentionally, the tortfeasor must want to bring about a particular consequence or must know with substantial certainty that a specific result is going to happen. If the tort is committed recklessly, the defendant must act in deliberate disregard of the emotional distress that he knows that he is very likely to cause the plaintiff. This recklessness has to rise above negligence. This is also known as extreme and outrageous conduct. So outrageous conduct is any conduct considered intolerable in any civilized society and is characterized as exceeding all possible bounds of decency. Courts differ on how they define severe and outrageous conduct. In the KFC case in 1992, the employee supervisor accused her of stealing money from the store safe, ordered her to take a polygraph test, and in front of customers and other employees, took away her store keys and suspended her for 10 days, pending an investigation. Because of the personality traits of this specific employee, to which the employer was unaware, the employer's actions resulted in the employee's hospitalization for depression and severe suicidal tendencies. In this KFC case, the court held that because the employer had no knowledge of the employee's peculiar sensitivities, no cause of action may have existed. Now, in a second case, Doe versus Mills, which happened just 3 years later, 1995, members of a religious order protested outside an abortion clinic, holding up large signs displaying the real names of the plaintiffs and begging them not to kill their babies. The trial court granted the defendant's summary judgment, but the appellate court reversed on the grounds that reasonable persons could conclude that the defendant's conduct was sufficiently outrageous and extreme as to warrant liability. So there, the courts observed that the defendant's actions were more than just mere insults, indignities, threats, annoyances, or petty oppressions. So as you can see, these are two very different cases, and the courts ruled differently in each one. I'm curious to know what your thoughts are. Do you think the court ruled correctly in the KFC case, and what about the Doe case as it relates to extreme and outrageous conduct? Before we move on from intentional infliction of emotional distress, I did want to mention that the doctrine of transferred intent generally does not apply to cases of intentional infliction of mental distress. There is one exception, however, when the defendant directs his conduct against a member of the plaintiff's immediate family and is aware of the plaintiff is present at that time. So, for example, if a man severely beats a child's father and he knows that at the time of the beating the child is watching, he will be liable for any transferred emotional distress that's suffered by the child. So the child meets the elements of being part of the immediate family and that the defendant is aware that the child is watching. So in that case, the transferred intent doctrine will apply to the infliction of mental distress. Finally, for the tort of infliction of emotional distress, a plaintiff must prove that he or she actually suffered severe emotional distress and at the very least sought medical attention. Some courts will require a physical harm requirement, although most modern courts now have done away with it, but at the very least the plaintiff should show that they sought medical attention, whether that be for therapy, for getting medication, something to attach to their severe emotional distress, and the proof that they suffered an actual harm. We're now going to move on to intentional torts against the persons. We're now going to move on to intentional torts against the property, but before we do, let's do a summary of the intentional torts against the persons. Again, battery is the intentional infliction of harmful or offensive conduct. The awareness requirement is not necessary in a battery tort. In contrast, for an assault, this is the intentional causing of apprehension of harmful or offensive contact, in which case the plaintiff needs to apprehend and be aware of the impending contact. False imprisonment is the intentional confinement of another. Don't forget about the exceptions for law enforcement and shopkeeper's privilege. And then infliction of mental distress, or mental distress as a result of extreme and outrageous conduct, which can also be committed recklessly as opposed to intentionally. Now moving on to intentional torts against the property. We briefly covered trespass to land when we first started this semester. A person who enters or wrongfully remains on another's land has committed the tort of trespass to land. On the same page, trespass occurs if an individual fails to remove an object from another's land if he or she is under a duty to remove it. Before, under common law, trespass was considered a strict liability tort. However, recently, there's no longer any strict liability for trespassing, except as it relates to abnormally dangerous activities, which we've covered in the past weeks, such as crop dusting and blasting. The defendant's only intent under a trespassing tort is to make physical contact with the plaintiff's land. He need not intend any harm to the plaintiff's property, nor even be aware that any harm might occur. A defendant will still be liable for a trespass even if his contact with the plaintiff's land is a result of a reasonable mistake. A defendant's indirect invasion of another's property can also rise to trespass. So the defendant need not enter or make contact with the land herself. So for example, if a child fires his BB gun at the plaintiff's barn, He is liable for trespass even if he never sets foot on the plaintiff's property. Another example is if a person builds an embankment next to her neighbor's property, and during a regular rain, the dirt washes from her land to the other's land, she'll be liable for trespass in this situation as well. Even a defendant who allows gases or particles to enter the plaintiff's property will, according to some modern courts, be liable for trespass. Trespass can also be committed if a defendant who has permission to enter the plaintiff's land refuses to leave when the permission is revoked. Similarly, if the defendant refuses or neglects to remove something when she is supposed to, she may also be liable for trespass. So for example, a person's given permission to park his car on the plaintiff's land for 1 month, and at the end of the month removes their car, but forgets to remove the gas can that he puts next to the car. In this situation, he has still committed a trespass. The extent of liability in a trespass tort is vast. A defendant will be liable for almost all consequences of the trespass, no matter how unpredictable those consequences might be. In some courts, he might also be liable for any emotional distress suffered as a result of the trespass, even if the plaintiff suffers no physical harm. So what about trespass to one's property or tangible property, also known as chattels? Trespass to chattels is committed by the intentional interference with the plaintiff's use or possession of their personal property. Chattel is property that is visible, tangible, and movable. A defendant who damages a plaintiff's silverware or who deliberately hides a plaintiff's bike so as to deprive him of its use has committed trespass to chattels. It doesn't matter how long this property has been deprived. It could be 2 minutes or it could be 2 weeks. It's irrelevant. Recovery will be allowed even if the loss of possession is just temporary. Keep in mind that the owner of the chattel need not be in possession of the chattel at the time the trespass occurs, and both the owner and possessor of a chattel are entitled to sue. In a conversion tort, if the defendant's interference with the plaintiff's property is so substantial that justice demands that she pay the plaintiff the full value of the property, the defendant in this case has committed the tort of conversion. Similar to trespass to land and trespass to chattels, there's no intent to harm the plaintiff's property or possessory rights that are required. An innocent mistake by the defendant is enough to prove or to raise a claim of trespass to chattels and conversion, as well as trespass to land. The plaintiff only has to show that the defendant intended to interfere with her possessory rights. So what's the difference between conversion and trespass to chattels? According to the Restatement of Torts, there are 6 different factors that are considered in determining whether a conversion has taken place, and an interference of someone's chattels has risen to the level of conversion. The courts will look at the extent and duration of the defendant's exercise of control over the property, the extent and duration of the resulting interference with the plaintiff's right to control, the defendant's intent to assert a right inconsistent with the plaintiff's right of control, the defendant's good faith, the harm done to the chattel, and the inconvenience and expect caused to the plaintiff. So a defendant who is in possession of the chattel at the time a lawsuit is brought up still has the opportunity and the right to return the goods in the case of trespass to chattels. Returning the goods, it could be an effort to mitigate the plaintiff's damages. In the case of conversion, however, title is deemed to already have transferred from the plaintiff to the defendant because of the defendant's interference. So this is kind of like a forced sale. And the defendant in this case is required to pay the full value of the property. Conversion can also be committed in other ways besides taking possession of somebody's property. A defendant can also be liable for conversion by the removal of goods. This removal must create a relatively serious interference with the plaintiff's right to possession and control of his or her property. So let's say, for example, a defendant takes possession of a house of which he and the plaintiff are co-owners. If the defendant removes the plaintiff's furniture when they became engaged in a dispute, he could be liable for conversion if he refuses to make the furniture available when the plaintiff demands it back. However, if the defendant complies with the plaintiff's request, the defendant's interference will constitute trespass as chattels, but not conversion. In the latter case, the defendant's interference is not so severe as to constitute conversion, but can still be considered intermeddling with the plaintiff's goods, which is the essence of trespass as chattels. Conversion also occurs when the defendant transfers chattel to someone who's not entitled to the property. So, for example, a parking lot attendant who intentionally refused to return the plaintiff's car to him is liable for conversion if this refusal is done in bad faith and the resulting interference with the plaintiff's right to possession is substantial, which arguably it is because it's his car and he's not being given it back. What about intangible items? Can these be converted as well? So in terms of stock certificates, promissory notes, insurance policies, bank books, some courts have allowed conversion suits for these types of items. However, they do have to be linked to some kind of document or tangible document, paperwork, to support a conversion action. So Exhibit 3.2 is a summary of the intentional torts against the property versus trespass to land, intentionally entering or wrongfully remaining on another's land. Trespass to chattels, intentional interference with another's use or possession of chattel. And then if it's a substantial interference, it could rise to conversion, which is intentional interference with another's use of possession or possession of chattel to the extent fairness requires that the defendant pay the full value of the chattel. So what are the defenses to these intentional torts? Mistake, unfortunately, in and of itself is not a defense to intentional torts, although it could be a point of reference and consideration in some of the other defenses. So Exhibit 3.3 provides a full breakdown of all the defenses to intentional torts. Consent is one of the biggest, the main defense. If a plaintiff who has a capacity to consent to interference with his person or property voluntarily does so, either explicitly or implicitly, the defendant will not be liable for such interference. Self-defense. A defendant is entitled or privileged to use reasonable force to protect himself or another against imminent harm if he reasonably believes it's necessary to do so. Most courts require that any person being aided must be privileged to act in self-defense. So for the self-defense requirement, what they're really looking at is reasonable force. And they're also looking at the objective standard here of whether or not a person in similar circumstances would feel necessary to use self-defense. Again, it has to be imminent harm, so not future harm will not be sufficient for future threat of harm will not be sufficient for one to argue self-defense as a defense. Okay, defense of property. A defendant is entitled to use reasonable but not deadly force to protect his property against imminent harm if he reasonably believes it is necessary to do so, and he verbally demands that the intruder stop first if circumstances permit. So in defending his property, they can use reasonable force so long as the harm is imminent. Some states will require a verbal demand, but assuming that the defendant still has an opportunity to yell stop, and they aren't going to be attacked right away. So that's very fact specific. What about the defense of regaining possession of chattels? A property owner is entitled to use reasonable force to regain possession of their property if the chattel was wrongfully taken and the owner is in fresh pursuit. So courts haven't really defined fresh pursuit, but basically, as soon as their property was taken, the defendant or the owner quickly engaged in trying to regain possession of their chattel. So if they waited a couple weeks or some amount of time had passed by, at that point, a property owner will no longer be able to use a defense of regaining possession of chattels. And also, if it turns out the chattel was not wrongfully taken, in that case, again, the defendant or the owner will not be able to raise the defense of regaining possession of chattels. What about reentry on land, especially as it relates to landlords? In some states, a landowner may use reasonable force to reenter his land, although the majority of courts deny that right to landlords attempting to evict tenants. As it relates to landlords trying to evict holdover tenants or tenants who refuse to leave the property, landlords will have to engage in the legal court system to evict their tenants and not take matters into their own hand. Okay, what about public necessity versus private necessity? Under the public necessity defense, a defendant may harm the property interests of another when necessary to prevent a disaster to the community or a substantial number of people. No reimbursement of the plaintiff is required. So if there's a fire on a neighbor's property and it's about to spread to the entire community, a defendant can use fire retardant or whatever they need to, which will likely destroy their neighbor's property, but under the public necessity defense, they're doing it to prevent a disaster to the community, and in that case, they wouldn't have to reimburse the plaintiff for any damage that they did to their property. Now, under the private necessity defense, a defendant can harm the property interests of another if necessary to protect his own interests or those of a few private citizens, just himself or just like one other person, because there's no less damaging way to prevent the harm exists. Reimbursement of the plaintiff is required if there is substantial harm to the plaintiff's property. So keep in mind that for the private necessity defense, there doesn't necessarily need to be a severe danger. So let's say there's an obstruction on the road and the only way through it or around it is to drive through this individual's property, their driveway. This would be a private necessity defense. Let's say in driving across the neighbor's private property, the individual asserted the private necessity defense, but accidentally ran over that neighbor's mailbox. In that example, the defendant would have to reimburse the neighbor for the damaged mailbox when asserting his private necessity defense. That concludes our chapter on intentional torts. I included in the modules just an article I found about a San Bernardino family who's suing Starbucks for a few intentional torts, among them including assault, battery, and intentional infliction of emotional distress. Go ahead and check it out, and I look forward to reading your discussions for this week. Thanks for listening.